The title of this talk is Tracking Everyone, Everywhere, All the Time. Whether you know it or not, if you use credit cards, make purchases at stores using barcodes, carry a smartphone, or regularly use the web for making reservations, viewing movies, or finding information, this is the world in which you already live. I want to talk um, about the issues of privacy and commercial free speech within a ubiquitous location tracking society such as we have in the United States. If the work at our universities is any indication, we're going to see more and more sensors everywhere. Sensors that see, hear, smell, feel, locate, and communicate. We're indeed entering the sensor age. Hundreds of forms of tracking devices are emerging that will all be interconnected in our future. In fact, Wired magazine estimates that over 1 trillion devices will be networked by the end of the next decade or so. The rise of the smartphone has given us a natural way to interact with millions of smart objects that are being deployed in our daily physical environments and carried on our persons. And of course, we will all gain myriad benefits from these devices that we haven't even dreamed of yet. Why is it important to protect personal information privacy in this pervasive technological future? Well, a first reason is we want to protect privacy to minimize burden. We as individuals should be left alone and not bothered. The law should protect us from being harassed and protect us from having our time and resources wasted through unwanted, intrusive contacts. Another reason is privacy is dignity. Although we may not be burdened by a stalker because we don't even know stalking is happening, there is something indignant and insulting about your neighbor, government, or the business sector tracking your electronic searches, transactions, and physical movements without your knowledge and permission. Most citizens don't even realize they are currently being manipulated by hidden tracking. And then we have privacy as a substantive right. Privacy is a way to constrain the power of the state to regulate. Those subjected to the Stasi in East Germany, Mussolini in Italy, or the Nazi regime across Europe have this concern much more embedded in their national psyches than we do in the United States. History shows that, even in purported modern democratic societies, extremists, despots, and lawbreakers can and do gain control of local to national governments. When that happens, detailed records on citizens can cover all of us. If certain areas of your life are off limits to government, it can't effectively regulate those aspects of your life. So, if we believe personal information privacy is a value worth supporting, the challenge for our academic community then becomes, how can we design and implement pervasive observation environments allowing protection of privacy without lessening the beneficial uses of these tracking technologies? Let me point out that the primary problem is not technological. The computer science literature is rife with methods by which we can provide the vast majority of desired internet and location services without tracking identity. The problem is that business and government almost always opt for system solutions that gather and retain who you are and what you did if it's within their power to do so. The challenge for society then is, well, how do we motivate them not to do so? I want to start this discussion with a case decided this last week in the European Court of Justice. In this case, a Mr. Gonzalez complained that when any internet user entered his full name into a Google search, the list of results would display links to 2 articles in a Spanish newspaper from back in January and March of 1989. He complained that the real estate disputes linked to his name had long been resolved, and reference to those links was now entirely irrelevant. The case was brought against Google by the Spanish Data Protection Agency under the EU Directive on the Processing of Personal Data. Mr. Gonzalez claimed that he had a right to have the links removed and, in essence, a right to be forgotten after a certain time. Well, the European Court of Justice agreed. Now, the language in the case makes it clear that Google must respect his request to remove the links, even though the articles may legally remain on the website of the newspaper. The court also held that in determining whether or not a link should be removed, a fair balance should be sought, in particular between the legitimate interests of internet users and the data subject's fundamental rights, and in particular the right to privacy and the right to protection of personal data. If Google refuses a request to remove a link, the complainant may appeal to the appropriate data protection agency, and Google can be fined if they guess wrong in their balancing process. This opinion likely means that we in the United States will still be able to find the links to Mr. Gonzalez through a Google or through a search of Google while we're sitting here in the US. But if you search google.es, or in other words, google.spain or google.com while you're sitting in Europe, you'll not be able to get those same hits. How big is the technological challenge for Google? Well, part of the reasoning of the court seems to be that if Google can limit searches such that people located in Germany cannot get hits on buying Nazi paraphernalia, and if Google, which owns YouTube, can prevent the posting of copyright-protected content on YouTube and do so on a nation-by-nation basis, well, then they should also be able to limit access to hits on personal name searches on a nation-by-nation basis. Let's quickly take note of the YouTube content violation processing situation. In that instance, legal owners of content provide to YouTube copies of their audio and movie files, right? These are the owners. Well over 5 million such reference files have been supplied by owners. YouTube then checks every uploaded movie file against their entire set of video and audio fingerprints. It's a huge job since users of YouTube upload approximately 24 hours of video to it every single minute, right? Every single minute, 24 hours a day, 24 hours of video are uploaded. Now, if a match is indicated for an uploaded file, YouTube does what the content owner has requested. Now, the content owner can choose block, and in that case, the video or audio is not posted. They might also choose track, and in that case, the video is kept online, but the owner has access to who is viewing the derivative video and their locations. Or the owner might choose monetize, and in this case the video is kept online and the original owner has the ability to place ads next to the videos using their content. And many songs and movies have gotten great surges of new life with new audiences through the non-permissive postings, and this has greatly increased their sales from this particular process. YouTube itself generates 1/3 of its profits from these otherwise illegal copyright violation postings. Content owners can also specify different response options for different nations across the globe. However, in the current privacy case, limiting access to certain links on certain personal names in certain countries is a much more expensive proposition. There's no obvious way to make money off of the link removal process. Rather, it's going to be expensive. How does Google rationally make the balance of judgment on whether a specific removal request will be honored? How does Google determine on a case-by-case basis whether the person requesting removal of the link is the person to whom the link applies? Well, with all of the information Google already has on each of you, Google can probably make a highly reliable estimate of whether the links you are requesting to remove actually relate to you. However, most of the judgment calls they will need to make can't be completely automated. One estimate is that it will cost Google about $15 million per year across Europe to support the link removal process. Now that's actually chicken feed compared to their $60 billion per year income, but it will be a much greater financial challenge for companies like Bing and Yahoo, and certainly for any startup browser companies. Let's assume, however, that Google does indeed succeed in accommodating the European Union law. Can we force Google, Bing, Yahoo, Twitter, and Facebook to do the same thing here? Now, before we address this question, let's first ask, why aren't these companies already doing the right thing and protecting our personal information privacy? Well, part of the answer is that their core functions can't operate at maximum efficiency unless our every move is tracked. For instance, as we all know, and as James Boyle has highlighted, 99.99% of content on the internet is junk. I don't care about it, and neither do you. It's not germane to what we want to know. How then can we find that small amount that we do care about? Well, we can only find it because it's been parsed, not by content, but by a second layer of content called links. Links that human beings have created. If a bunch of your academic peers that know you and know your work link to your online works, and you in turn link to theirs, and lots of other people and organizations and publishers follow those links through day-to-day activities and communications, your work and that of your peers arises out of the vast digital garbage dump. It's given extra relevance by search engine algorithms. Open web links created by humans and constant use of those links by other humans validates and authenticates materials that we would otherwise never find. It takes large bodies of humans to constantly make judgments, right? So keep in mind that we're doing this every single day, 24 hours a day. And by taking actions on those judgments, it's these actions upon which the whole automated sifting and winnowing process of the web depends. So yes, we are reading and consuming the web, but the web is also reading and consuming us. Every time you follow a link, you are being tracked. You are not only sharing with your friends, but with your super friends like Google, Twitter, and Facebook. Of the top 100 most visited websites across the web, Wikipedia is the only one that's not also watching you. So remember, if you're not paying for a service, you probably are the service. We didn't build the web with anonymity in mind, and in retrospect, that was probably a mistake. So this brings us back to my legal question. If they won't do it voluntarily, can we again force Google, Bing, Yahoo, Twitter, and Facebook to remove links upon request in the U.S.? Well, for those of you living in the U.S., you know that we have a right to access certain business records about ourselves, such as health, financial, and credit reports, but as a general proposition, we have no right to know what data most businesses have tied to our identities, nor a general right to correct data that businesses hold. That data is typically protected by trade secret laws. The standard business practice is to trade and sell information about all of our digital transactions and digital tracks for, quote, legitimate business needs. And it is the trading businesses that determine whether such transactions are legitimate. In the U.S., one should assume that every digital transaction or web track that you've ever made in the past 25 years has been consolidated within massive server farms and is daily accessible and used by the business community. If you can't point to a specific law indicating that specific data can't be retained, be assured that it is being retained and it is being traded. Just read the literature on this topic. We protect privacy in the U.S. only on a very ad hoc basis. Let's propose another ad hoc law. Let's propose in a search for a named person, let's assume in a search for a named person, businesses must, I keep moving this, in a search for a named person, businesses must remove upon request from the list of search results those links to which the person objects. Okay, so let's assume that 90% of us in the general population, we strongly support this. Federal legislation is passed along these lines. Does this new law solve this problem? Well, possibly. However, in the U.S., we would have numerous federal conflict of law issues to resolve. Further, the constitutional law challenges would very much present an uphill battle. Corporations are persons under the constitutions. Yet, due to their ability to accumulate massive wealth, due to their legal obligation to not pursue moral objectives if to do so fails to maximize profits to shareholders, and due to the fact that they can live much longer than any human, corporations can exercise their personhood rights much more fully than any human. As a corporate person, the Bill of Rights applies as much to them as it does to you and me. Thus, they are super persons under the law in comparison to mere humans. As a result, corporate personhood rights in property and free speech, as well as corporate commerce clause rights, are aligned against the human right of privacy. Therefore, the law as it exists today in the U.S. is stacked against the protection of personal or individual privacy. Now, you probably thought that the Founding Fathers were referring to humans when they referred to life, liberty, and the pursuit of happiness in our Declaration of Independence, since, of course, a corporation can't be alive. Corporations can't have liberty since they can't be put into or released from bondage, nor can a corporation be happy. However, the U.S. Supreme Court has controversially interpreted our Constitution to mean that the Founding Fathers must have also meant that this social construction we call a corporation would have also been protected by the Founding Fathers with the same rights as humans had they thought of it at the time. And by the way, corporations did exist at the time and were not explicitly included in the Constitution because, of course, the first corporation was created in England in 1712. The proposed delinking law also has a serious censorship problem since the law may impinge on my free speech right to make bad things widely known about another person. Well, let me try then a second example, if that one works. And this is an example more directly tied to our disciplinary domain. Let's pass a law that states businesses may not link people's identity to their sensed location without first obtaining their explicit permission. And again, large percentage of the population strongly supports this. We go tell our members of Congress, they pass a new federal legislation, so we've got a new law on the book. Does this law largely, again, solve the location privacy problem? Well, this location privacy law would clearly be unconstitutional in the U.S., at least under our current sitting U.S. Supreme Court. Again, the problem is that corporate freedom of speech trumps individual freedom from trespass or individual privacy in the United States. Similar legislation enacted in the past has been found to be unconstitutional. We have direct case law indicating that you can't force an opt-in economic model on corporations over an opt-out economic model. Okay, well then, if those won't work, what has worked? Well, let's say we pass a law which establishes a centralized, legally enforceable, do not link registry with automated checking at the time of purchase of goods, face recognition, match, etc. Under this instance, corporations and agencies are forced to check the registry each and every time they want to link your identity to determine whether you have opted out. So the results here would be that if a person is registered, you go register yourself with the federal government, you may, then a corporation or a business may not link the person's identity to their sensed location or other sensed information without first obtaining their explicit permission. Now, I would actually add some additional provisions to this law to reduce its adverse effects on businesses. For instance, I would add that plaintiffs must request delinking prior to pursuing a lawsuit, and if the company did that expediently, the case would be dropped. After all, if privacy cases are too easy to win, then they would indeed chill corporate free speech rights. Further, I would specify statutory damage, and I would want those statutory damages per violation to be relatively small yet significant. Here I would say, and the reason for doing this is that occasional missteps by businesses and governments then would be unlikely to generate lawsuits. However, egregious conduct would be pursued. I know many lawyers would jump on a class action suit if there were thousands or millions of violations by a large corporation, because then you could go after the statutory damages for each and every one of those particular violations, and even though small, they could certainly then build up. So I think a do not link registry legal solution has great potential. Because this solution provides most of the benefits of sensor networks, and tracking are retained, right? The benefits of these networks and the tracking they do is retained, yet abuses are constrained. Automated permission, these automated permission requests educate users, and this is a good thing. Consent becomes informed rather than a pro forma bothersome action as we have seen in some other nations. But more importantly, this approach drives technology towards anonymity rather than confidentiality. This lessens security concerns, right? If your identity isn't contained in a stolen data collection, your security is greatly increased, right? The corporations have an incentive to make sure that application developers simply do not link in the first place. I also like this approach because anonymity is breachable in appropriate instances by court order. In other words, relinking is possible. So, by example, let's say you track the locations of 1 million people using their cell phones over the past year in the Los Angeles basin, as virtually every phone carrier is currently doing. Further, let's say the phone company does not in any way tie a person's identity to their cell phone tracks. How many spatial temporal points would the police need in order to discover which of those 1 million track histories was yours? Well, the answer is 4. A recent study by MIT and Louvain University found it takes only 4 such points to determine with 95% confidence which set of phone IDs was your set of phone tracks. Thus, the burden on police is minimal when they have a valid reason for knowing where your cell phone traveled over the past year and at what times. I also like this solution because, as we saw with the do not call list, checking occurs at the speed of light. And similar laws have been upheld as constitutional under free speech, and they are morally defensible. This approach supports the autonomy of each individual to decide on their own level of information exposure. I think it's very practical. The do not call list changed practices overnight. And I also like it because it's enforced primarily by citizens rather than the state. The law stays in the background. the norms of society become embedded in the information system architecture. By the way, I should comment here that Cory Doctorow of Boing Boing fame would disagree with me. He argues that companies like Google should indeed do no evil and redesign their browser processes to protect our privacy. He believes that users would flock to a privacy-protecting web browser. However, now that it has stockholders, a company like Google needs to follow the obligation of do nothing illegal rather than do no evil, when that path would conflict with Google's shareholder interests. Further, voluntarily protecting privacy while your competitors don't has typically resulted in major losses in the marketplace. Now, I do agree that there are some drawbacks for individuals if you follow my recommended do not link approach. Number one, you need to uniquely identify yourself to the government in order to gain the protection, right? It's not simply, providing them with a phone number with that phone number being protected. You need to conclusively identify yourself to the government. However, in most societies, we're well down this road anyway. I think we should take advantage of the national ID to control linking of records to that ID. Because if we do nothing, the market, technology, and current laws are marching us towards even greater pervasive surveillance across all aspects of society. There are also some drawbacks for business, right? Individualized marketing to consumers that opt out of being tracked is a greater challenge. Plus, new costs would need to be borne by social media companies for people that want to expunge certain links. So, let me wrap up with some queries. What's the likelihood of actually passing federal legislation that would drive technological developments in the market towards morally defensible, ubiquitous tracking? If enacted, what's the likelihood of passing constitutional muster? Well, under our current U.S. case law precedents, I believe the do not link approach would and should be upheld. However, in my opinion also, we appear to have currently an activist judiciary that seems to have few trepidations in overturning previous precedents in pursuit of corporate causes. We're now largely stuck in a system that does not recognize Congress's right to say no even if it wants to. Thus, if your goal is to comprehensively protect personal privacy in our emerging ubiquitous surveillance world, I think right now you're fighting a battle in the U.S. that you simply won't win. Some conclusions. Again, I think it's certainly feasible to protect both privacy and commercial free speech technologically in our ubiquitous tracking future. There are no major hurdles from that perspective. Whether we have the political will to accomplish absent a national catastrophe, I think is unlikely. And the kind of national catastrophes I'm thinking about would be something like a new McCarthyism era, such as we had in the U.S. in the past, or perhaps a Nazi rule situation where people are persecuted by society for their personal associations. Now, after analyzing this issue, some people are torn between Scott McNeely's stated philosophy from back in 1999, right? Well, you have zero privacy anyway, get over it, right? Smile, be happy, folks. If we ignore the problem or insist that no problem exists, perhaps it will go away. Versus the philosophy of Derek Jensen. Although all hope has died, that's where action begins. I'll do whatever it takes to protect the people, the things, and places I love. And I would argue that many more Americans right now are in this latter category, as evidenced by the huge concerns being expressed currently over individual information privacy. And particularly, we're seeing this from the far left and from the far right. It's interesting that these two groups are very much coming together, as well as the average citizen in the United States has major concerns in this area. If acquiring a constitutional amendment to support human rights is not feasible as opposed to corporate rights, there's an interesting legal movement arising within the environmental arena where, again, most of the existing laws and their constitutional interpretations are aligned in support of the corporate sector and against protecting the environment. The movement's approach is to scrutinize and challenge the right of corporations to operate in local communities if the corporations do not abide with the community standards. The corporation is a legal or social construct that we the people created, and therefore we the people have the legal right to also deconstruct or reshape this entity. So the movement is getting some traction, and the results may very well have some lessons for privacy protection advocates. Thank you very much, and I've got a few slides that I'll simply click through for a while, and thank you very much.